Well, a very warm welcome from Prime Finance for this Prime Time virtual event. The subject of the first in this series is dispute resolution in a pandemic. And particularly warm welcome to all of you, many attendees from all around the world, particularly those of you who've stayed up late in your evening in the markets in Asia. We're going to cover a number of topics in today's session, including market volatility and dispute resolution. Why does market volatility lead to disputes? What types of disputes are likely to arise in the wake of market volatility? How are courts, arbitrators, and parties dealing with the complex financial and business disputes in this time of pandemic? How are disputes being managed and determined remotely? And is now the time to break away from convention and seek creative solutions for dispute resolution? A few housekeeping notes to begin. This session is being recorded and will be distributed at a later date. Attendees who continue to participate will be taken to have consented to the recording. Attendees are all muted and have their video and chat box turned off. If you have a question or comment, and we hope that you do, whether for the panel or of a technical nature, please use the Q&A function to get in touch with us. We will use the chat box to send messages to all attendees. I'd like to thank Lexis and MLEX for their support of Prime Time and for their assistance with promotion of this event. And I'd in particular like to thank DWA Financial Technologies for their sponsorship of the first in this series of Primetime virtual events. It's now my pleasure to introduce the excellent panel of speakers that we have for our session today. Firstly, financial list judge in England and Wales, first president of the Board of Appeal of the European Supervisory Authorities, currently professor of financial law and ethics at Queen Mary University in London, an arbitrator at 3VB in the UK, a Prime Finance expert and a member of Prime Finance, the Prime Finance Advisory Board. Joining Sir William is Jean Messinesi, former president of the Paris Commercial Court, currently board member of Banque Internationale Arabe de Tunisie, and senior advisor at Zales SA. Jean is also a Prime Finance expert. And joining Sir William and Jean will be Judge Elizabeth Stong. Judge Stong is a judge in the U.S. Bankruptcy Court in the Eastern District of New York. She has a leadership role in a number of American Bar Association, New York City Bar Association committees. She's on the Columbia University Committee on Global Thought. She also serves as a member of the Prime Finance Management Board and is a Prime Finance expert. My name is Rick Grove. I'm the CEO of Rudder Associates, a global financial markets consulting firm. We're very active in dispute resolution. I'm currently acting as an expert in financial markets disputes in Hong Kong, London, and in the United States. I'm a former derivatives, fixed income, and commodities banker at Bank of America and BNP Paribas, now part of BNP Paribas. I'm also a former CEO of ISDA, and I began my career as a lawyer with the American firm of Cravath, Swaine & Moore, posted in both their London and New York offices. I'm also a member of the Prime Finance Management Board and a Prime Finance expert. Each of the disputes that arise when we see bouts of market volatility of the sort that we have seen. The pandemic, which we are experiencing globally, is a human tragedy. It's an economic catastrophe, and our thoughts are with all of those who have been gravely affected by this crisis. One of the consequences of the crisis for the financial markets has been abnormally high levels of market volatility. most notably the volatility that we experienced in March in the equity markets and in the oil markets. As we saw in the autumn of 2008, following the collapse of Lehman Brothers, market volatility of this sort leads to wide bid-offer spreads and diminished liquidity in the markets. And these factors, in turn, create the potential for disputes. I'm going to talk about five disputes that we have either been seeing in the last couple of months or that we believe are likely to arise in the coming months. This is not an exclusive list, but these are five that we will certainly have seen or will see. Firstly, most immediately, wide bid-offer spreads and the lack of liquidity lead to disputed calls for margin and collateral. The reason for that is that with a lack of liquidity, it's more difficult to determine prices, to determine marks to market, and that can lead to disputes. The initial margin or independent amounts that are collected at the outset of a transaction to provide a buffer for market swings are often dwarfed by the size of the market swings that we have seen in this crisis and are inadequate. And so the mark-to-market or variation margin that is posted on a daily basis is critical to providing credit support. The discrepancies that can occur, the disputes between parties can be quite substantial. And we have already seen disputes arising from margin calls. A second area are issues around force majeure and business interruption and possibility of performance. Market volatility of the sort that we've seen can lead to these types of issues arising. Thirdly, getting on the wrong side of a big market move can lead to insolvency. And we've seen some insolvencies among financial institutions in the wake of the market moves in March, although fortunately none of them has been on the scale of Lehman Brothers. But nevertheless, there have been a number of financial institutions that have become insolvent as a result of being wrong-sided by these very dramatic market moves. A fourth area of concern where we believe that disputes, in fact, some disputes have arisen and others will arise, is in the area of commercial mortgage-backed securities. And those of you who lived through the global financial crisis of 2008, 2009 will remember that it was residential mortgage-backed securities that precipitated, or were one of the precipitating factors in that crisis. In this case, commercial mortgage-backed securities, similar to residential mortgage-backed securities, except that these are securities that are backed by pools of commercial mortgages, not residential mortgages. These commercial mortgage-backed securities depend upon the commercial real estate firms who are borrowers under these mortgages being able to service their debt. And their ability to service that debt depends upon their ability to collect rent. And if we look at what's happening in markets around the world, to various retailers, restaurants, bars, offices, who are simply not able to pay their rent, it's only a matter of time before some of these securities come under pressure. And the types of disputes that will arise, some have already arisen relating to CMBS that were in the pipeline and whether they can go forward or not. And there are others that will arise relating to issues of fraud, misrepresentation, the sorts of issues that we saw in the RMBS market, we are likely to see in the CMBS market going forward. And finally, a fifth area for dispute, a big market move can lead to losses in certain types of derivatives trades that are structured with an asymmetric risk-return profile. That is to say that one party to these trades has a high probability of consistent but fairly small returns. And in exchange for that high probability of consistent but small returns, that party takes a risk, albeit a low risk, but a risk that it can lose on that transaction. But when it loses, those losses are often quite large due to factors such as leverage and other factors that exist in those contracts. And when there's a big market move of the sort that we've seen, there are parties that are on the wrong side of those types of trades. Now, the disputes arising from these derivatives trades often take months, if not years, to find their way into litigation or arbitration. But if the experience of 2008 and of some of the less remarkable but nonetheless substantial periods of market volatility between 2008 and today, if these are any indication, it's only a matter of time before disputes of this type will arise. Now, for those of us in the financial markets, the financial markets disputes world, the past few months have been very busy, and they are likely to get even busier. However, unlike the global financial crisis in 2008, we are now constrained by the difficulties of holding in-person meetings, negotiations, hearings, and trials in the midst of we're now facing these constraints. And this is the subject upon which my fellow colleagues are going to speak. And so without any further ado, I'd like to turn this over to Sir William.
Well, thank you very much indeed, Rick. It's a pleasure and honor to be here. I should just check that people can hear. And on that basis, let me start. I'll begin by thanking P.R.I.M.E Finance for setting up this seminar. It's produced a great response, and it shows how important the issues that we're talking about are and how current they are. So let me begin by saying something about the present position for bringing the kind of complex financial and business disputes that we're concerned with in this webinar. So I think we all know that the closure of physical courthouses has happened in many countries. They are now slowly reopening. And this has a practical effect on the filing of claims, or can. And that has led in some jurisdictions to the temporary suspension of limitation periods or tolling. Although in many countries, such as my own, electronic filing is available to a greater or lesser degree. But what this crisis has done is to give a huge boost to hearing cases remotely through one of the many systems that are available. And let me give you some statistics from the London Commercial Court. These statistics are as of 15 June. So there's been a slight increase in the number of actions commenced over the corresponding period of last year. But there's been nothing to indicate that the makeup of the claims has particularly changed. And I think that tends to bear out what Rick Grove said about the long tail that quite a few of these financial disputes have. The number of hearings is comparable to the same period last year, but full trials have had a higher settlement rate, and it's quite striking. About 75% compared with about 60 to 65% in previous years. So it's a reasonable assumption that the pandemic's had something to do with that. And finally, so far, there does not appear to have been an appreciable buildup of backlog. And I'll say a little bit more about backlog in a moment. But those raw statistics tend to obscure the overall loss of capacity across the court system as a whole. And again, let me try to give a number to that. And I'm going to take it from the CEO of the Scottish courts, who said a couple of weeks ago, social distancing requirements will be with us for some time and reduce our physical hearing capacity by 2/3. Now, if that is typical globally, which it may be in the near future, serious backlog seems to be inevitable, though it will vary from jurisdiction to jurisdiction. Turning to arbitration, that's a confidential process largely, of course, and it's harder to get statistics. But there do seem to be a considerable number of new arbitrations being filed right now. we'll see the full position when the arbitral institution statistics come out at the end of the year. Anecdotally, and I have experience of this myself, it seems that procedural timetables have, not surprisingly, frequently been extended. Hearings have been postponed. But as with the courts, hearings can and are taking place remotely, and arbitral institutions have all tried to encourage parties to keep things moving. So let me say something now about the type of disputes that seem to be arising. Disputes around the March volatility may have been limited by the recovery, of course, recovery in the markets, but not entirely, as Rick has said. And let me perhaps give an example of a dispute that flared up. And this really comes from the knock-on effect of the collapse of the oil price in April. And this hit wealth products which were linked to oil futures sold by the Bank of China. And losses well over $1 billion US were racked up by investors. Some of these were retail investors who bought the products on the phone. The authorities in China have encouraged an overall settlement, and I think that's something that we should expect to see more of. Financial regulators will certainly be wanting to encourage settlement in similar situations. And it goes without saying that they will if there's any question of some systemic implication. Then a massive area of dispute is around business interruption insurance. And this is an example of disputes which turn on the wording of the particular contracts. But they're also an example of disputes which are going to need, one way or another, to be settled by the courts. Prime Finance has been following now for some years the progress of the financial list, which we set up in England in 2016. And the business interruption insurance issue has been referred by our Financial Conduct Authority, which is one of our two financial regulators, to the Financial Markets Test Case Scheme, which is part of the financial list. This allows an interested party to bring a cost-neutral test case, on issues of general public importance, and it is the first time it's been used. The hearing will take place on 20 July. The tribunal will consist of a commercial judge and an appellate judge, both of them insurance specialists, and it will be live streamed. So other potential disputes, Rick has already mentioned CMBS, and this is going to be, I suspect, just one of the potential knock-on effects of the rent moratoria that have been put in effect in many countries. Remember, all that's happened, certainly in the States, as I understand it, and in my own country, is that payment has been deferred. It hasn't been abrogated. And of course, there's a vast area of potential disputes around supply chain. Bankruptcy and insolvency is a crucial area, but Judge Stong is kind of going to deal with that. Now, let me say something about some of the practical issues around trying cases remotely, and this really applies to litigation and arbitration. There's no doubt that this has been quite successful, and whilst not replacing physical hearings, it's a fair bet, and many have said this, that these remote hearings will become a permanent feature even when the health crisis lifts. But I think it's important to add some reservations. We shouldn't minimize the strain this has put on judges and arbitrators, as well as parties who've been trying to deal with these cases from home, often with suboptimal IT resources and other responsibilities such as childcare. Technical issues include producing electronic documentation, which is easy to navigate, which is an absolutely crucial part of remote hearings, ensuring sufficient screens and stable connections for all participants, and giving public access to hearings in accordance with the principle of open justice and proper provision for self-represented litigants. So my view is that commercial disputes may turn out to be particularly suitable for online hearings, and there are benefits. An obvious benefit is reduced travel costs. But I would say that managing a complex hearing with a large amount of evidence is going to be challenging for tribunals, lawyers, and witnesses, at least in the short run. There are also time zone constraints. A tribunal I'm chairing in a couple of weeks has members from Washington and Hong Kong, respectively, and obviously there's a limit to how long you can extend the day or contract the day at either end. One important point to mention are the number of protocols dealing with these issues that are emerging all over the place, and expect to see standardization in the future. As to delay and expense, which are the recurring criticisms of commercial dispute resolution, we've already seen before the pandemic creative solutions in the financial field, and I've mentioned ISDA's external review panel of various determination committees. And we're going to need people to think about these creative methods of dispute resolution in the future. We discuss this in a concept note published by the British Institute of International and Comparative Law. And I'm going to finish just by summarizing the conclusions that we came to. Bear in mind, of course, that much is going to depend on the economic backdrop. There's an old rule that litigation lawyers are busiest during a recession, but that won't necessarily apply if the recession morphs into a global depression. And there's another aspect of this that I think we need to think about. How should we be looking at these disputes in the future? There's a public interest here, given the massive liquidity pumped into economies to keep business afloat. Remember, this is funded by government debt. That debt is ultimately the responsibility of the whole community. So we should, in our view, be concerned at a plethora of disputes inhibiting the recovery. And in short, we answer that the best policy approach in the case of many contracts, obviously not all, is first to support negotiated solutions to make viable contracts blighted by the pandemic work. Second, to bring contracts made unviable by the pandemic to an end in an equitable manner. Third, where negotiation fails, to encourage parties to undertake mediation. And I've no doubt that mediation is going to have a much more important part in the future than it does now. Thank you.
Thank you very much, Sir William. Now let's move to Jean Messinesi.
Well, thank you, Rick, and good afternoon to all of you. Before addressing the points raised by Rick Grove, on which William just made some most interesting comments, I'd like to give you a brief account of how the coronavirus affected the judiciary process in France. Following President Macron's address on March 16, French courts seized virtually all activities except for essential litigation, quote, an emergency procedure mostly of a criminal nature, unquote. All other activities were to be postponed. And in fact, in the following day, the Minister of Justice, in a letter to the judges and court clerks and administrative staff of her department, made it clear that only hearings on criminal matters and on cases relating to minors, insofar as they were deemed very urgent, could be held. Recovering after 2 weeks of stupor, the presiding judges of the court's largest commercial courts, Paris, Lyon, Nanterre, and a few others, started to organize themselves to resume the activities of their jurisdictions. Thus, summary proceedings, which is called référé in France, started to be held within the court premises. But considerable efforts were displayed to arrange remote hearings, both in litigations on the merits and in bankruptcies. Also, the activities of prevention of business difficulties, which in France is a non-judiciary but court-controlled service, which aims at solving difficulties of businesses through the office of a conciliator or of a mandataire ad hoc, resumed in early April, as did the summary payment order proceedings known as injonction de payer. Thus, all in all, the work of the largest commercial courts as a vital public service, as Lord Mayor would say, did continue without naturally being back to normal. The real difficulty related to the organization of the remote hearings for litigation as well as for bankruptcies. The problem was to get the court clerks on board. Most of them had been sent home for undefined periods, and most were not adequately equipped to link up from their homes to the network software that was being used for these hearings. Judges, on the other hand, who, as you know, are all former or still active businessmen and women, who carry out their judiciary duties pro bono, were eager to get the court activities going. Rapidly, thanks to their unrelenting efforts, the business of commercial court successfully resumed as early as the second week of April. Curiously, after some weeks of experience in remote hearings, a certain number of judges and clerks feel that this was a good experience and they would continue on that path should the need arise. This crisis has put in evidence a certain number of facts. First, the consequences of underfunding justice for so many years and the poor digital equipment of courts and staff have come home to roost. We have also witnessed the divide between rich law firms and poor lawyers who could hardly afford the adequate electronic equipment, while the former did enjoy defending their clients' cases from comfortable and well-equipped rooms in their offices. Turning to the points made by Rick Grove, let me first seek your indulgence. I am just a former presiding judge of the Paris Commercial Court, and since I left 18 months ago, I have not always kept abreast of all the most recent developments on the impact of volatility on business relations. But it is probably a fair guess that given the volatility of certain underlying variables, stock exchange indices, energy prices as reflected in the WTI index, indices of a few primary commodities, there have been a number of situations where parties to derivative contracts have been following very closely indeed the options that were open to them. However, so far, I have to say that I cannot report any significant dispute brought to French courts based on volatility-induced breach of contract, a failure to meet margin calls, or more generally, a triggered cross-default clause. I see three main reasons for this. First, the fall in value recorded by these indices was brutal, but very rapidly followed by a sharp rebound that surprised many. Secondly, I believe that the situation was and continues to be exceptional. This has perhaps induced a number of parties to contracts such as ISDA, master agreements, to show some patience before triggering a chain reaction. Finally, I sense that the pressure that was put by governments, which after all are providing massive support, on corporations not to create a situation that would get out of hands, may have had a real effect. I have also another explanation, which is that I should mention it, that the bulk of disputes arising from the enforcement of financial contracts, be they ISDA or others, still go to London or to arbitration. We see relatively few in Paris, but I believe that we will see a few in the forthcoming months. Although I'm aware that the focus of this meeting is the impact of volatility, I would tend to be more concerned with forthcoming straightforward defaults on bank loans and threats of bankruptcies. The risk of a tidal wave of business failures does exist and is likely to materialize after the summer when government support is gradually whittled down. Our commercial courts should, in my view, get ready for an acceleration of bankruptcies. Liquidation, which resembles Chapter 7 and is a relatively straightforward process, while the adoption of a refinancing plan or debt rescheduling, more like Chapter 11, are much more complex and lengthy affairs, especially in France, where the court gets involved throughout the process directly. On the litigation side, as was already mentioned by Rick and by Sir William, there are two questions that have emerged in the wake of the sanitary crisis. Can defendant invoke force majeure, which naturally is not really a common law concept, but it is a civil law, a strong element. And the second point is, will business interruption insurance cover the consequences of the coronavirus lockdown? There have been only a very few cases heard in Paris Commercial Court. And we will wait till the Court of Appeal decides on these points to really have a feel of what's in the offing. The risk of a sharp increase of COVID-19 related cases brought to the commercial courts in the forthcoming months should not be underestimated. In response to this threat, a recent initiative by judges and lawyers and the support of the ministry was to establish a new efficient alternative way of settling disputes. And in France, the law has always sort of very strongly supported the idea of alternative way of supporting disputes. In France, this new initiative is called Tiers Conciliateur, and its proponent, the Paris Bar, the Paris City of Law Association, some law societies have organized this platform with the objective of mitigating the effect of the increase in cases when the Paris Commercial Court could soon be confronted with. Finally, and as a matter of conclusion, I would like to say that I believe that the sanitary crisis has served, if you will, as an electroshock treatment to commercial and, for that matter, civil justice at large. It has helped showing our shortfalls, particularly in the IT area, that we need to address rapidly if we want to harness the technological innovations that will allow us to remain a jurisdiction that will compete effectively on the international market for legal services. Thank you very much.
John, thank you very much. Now going to turn to Judge Stong, and Jean, you've given some very good make for a very good segue to Judge Stong, who is a bankruptcy court judge. So Judge Stong, over to you.
Yes, indeed, and thank you so much for that wonderful introduction of the topic that we are living every day in the bankruptcy courts in the United States, dispute resolution in a pandemic. I am a United States bankruptcy judge. I sit in the Eastern District of New York in Brooklyn. My court and our jurisdiction includes 3 of the 5 boroughs of New York City and all of Long Island. I want to share with you just a few thoughts about what's changed in the last 100 days or so, and also what stayed the same, perhaps also a few practical tips. Some of this will be very personal because we're living this in a very personal way, each of us involved in the court system these days. And I share these thoughts, not of course as rulings or of course as case-specific comments, and would be grateful that they not be viewed that way or cited that way. That's the judge disclaimer that comes with any kind of speaking like this. So what's changed and what stayed the same? I am on the bench so to speak, air quotes, 3 to 4 days a week, sometimes 5, and that has not changed. But my last in-person hearings in my courtroom, which I love, were on Friday, ironically, Friday the 13th of March. At the time, neither I nor my law clerks nor any of our court officials, nor I suspect any of the lawyers had any idea that we were holding the last in-person hearings in a courtroom for quite some time. I must say that it's June 24th, and I still don't know when I'm going to be returning to my courtroom, but I'll tell you this, we have not missed a step or a day in continuing to do the work of our court, not only because we are determined and dedicated public servants, but also because, frankly, we have no choice. In a bankruptcy situation, in a restructuring, in an insolvency, you can't say, well, we'll see you in a few months when we figure this out. Have a nice summer, have a nice spring. The company that can be restructured successfully now probably cannot be successfully restructured with a pause of many months, especially a pause in as difficult a time economically as this. We have concurrent jurisdiction in the federal bankruptcy system in the United States over consumer cases, the cases of natural persons, the cases of people trying to get caught up in those mortgages, the same instruments that underlay the prior financial crisis, housing, residential mortgages, and on family homes. Those cases too are time sensitive. They have their own kind of volatility. They cannot simply go on hold, and so they haven't, and we haven't, and beginning on March 17th, all of our hearings became remote. All of our staff became remote. Everyone is working pretty much from home. As a practical matter, if anyone who's watching knows me or has come to visit our court, and I hope you have, if you haven't yet, you know that I walk to work. I live in the neighborhood of my courthouse, as do many of the judges who sit on our federal courts here in the Eastern District. And so I actually have a particular luxury that I can hold my hearings from my desk. I have to say in all candor, wearing a shirt like this, not a robe, and sometimes on a warm day wearing shorts, but remotely, and sometimes, as I am at the moment, from my kitchen table. So that's a big change. We went to that in mid-March on almost no notice. It was a scramble, but thanks to the resourcefulness of our court staff, our law clerks, and I have to say the lawyers, we got it done, and I'll say we really didn't miss too many beats. Courts continue to respond to this crisis in a lot of ways. I don't like the word crisis, to the situation in a lot of ways. Our courthouses are open. Courthouses physically remain open places nearly every day, but they're not what they used to be. Had you come to my court 6 months ago, you would have seen a bustle of lawyers and clients and trustees in and out, United States attorneys doing the work for their clients and for our justice system. If you go today, if it's a hearing day, you might see me showing up. You would see 3 or 4 of our very dedicated United States Marshal Service officers, and usually 2 or 3 people from the Department of Homeland Security, because we are, after all, a federal court, and so we always have that protection no matter what. But you wouldn't see the action you typically see. Our staff is remote, our hearings are remote, they are virtually all telephonic. They are occasionally, and this is rare, and it's something that's been a real challenge. This was mentioned by Sir William. They are video when witnesses' testimony is required. In our practice, in the bankruptcy practice, in the insolvency restructuring practice in the United States, as a practical matter, very few hearings require witnesses. Most are based on an argument. Many are unopposed, and that we've been able to adapt fairly successfully, I think, really quite successfully, to a telephonic mode. But you can't assess a witness's credibility telephonically in the same way that you can in video. And I have to say, there's a gap between what you can do on video and what you can do in person. But in person isn't an option at the moment, and so dealing with the best available tools, some of my colleagues, though not me yet, have held evidentiary hearings using our different video platforms, including like this one, Zoom, WebEx, things like that. What does this mean as a practical matter? Well, we're still holding hearings pretty much the same days a week, Tuesday, Thursday, Friday, Mondays and Wednesdays for matters of special note. My colleagues the same. I've had hearings with 10 or 20 lawyers involved in the same matter. I've had hearings where both sides were pro se, people representing themselves. I've had, and they've all worked. They've all worked. I've had hearings with interpreters last week, both Spanish and Cantonese. Even that has worked, although I'll tell you, it's again, it's an incremental challenge. But we don't have the opportunity of closing down the justice system. It's just not. It's not one of the options. And so I have to say, we and the bar and the parties and our court staff are really, I'll say, rising to the occasion, doing their best. One of the challenges I think we face is that we have, I'll speak personally, someone may know how long this is going to last. That's not me. I have no idea. I have compared it, including based on some recent personal experience, to running a marathon where you know you're well prepared, you're going to get it done, you're going to be able to finish, but you don't know, are you at mile 6 or mile 16 or mile 26? It's pretty clear to me that we're not at mile 26. Hopefully we're past mile 6. We've adapted well, I think, to a difficult situation, but we don't know how much more of this we have to come. And we have that uncertainty against the face of a high likelihood of the busy court that we already are becoming a significantly busier court. It's probably 2 or 3 days a week that there's a headline in the newspaper, I think it was day before yesterday, in the New York Times, that there's an avalanche or a tsunami, they're very dramatic metaphors for this, of business bankruptcy cases that are coming. Of course, bankruptcy in American English means the entire toolkit of restructuring and value-preserving steps that courts can take, that businesses can take in a court. So we know that's coming. The things that are different are that it's harder to do what we usually do in the ordinary course in our cases because of the remote hearings. We've learned we can do more remotely than we thought, and we've learned some lessons, I think, in the bar as well about how to do this effectively. I see there's already one question about mediation and whether it's going to be a more effective tool, and I'm awfully glad to see that because I think the answer is going to be an emphatic yes. I've heard at least one financial services lawyer representing a large Wall Street entity indicate that they're maybe going to take a kinder, gentler approach in the near term, that there's going to be an outbreak of common sense because we are all in this for the long haul, and the winning today step may not be the value preserving step, you know, into the next quarter or through the end of the year. So we're mindful of that. We know that's coming. I think we're ready for it, but it's kind of a one step at a time. A couple of personal thoughts. I miss the courtroom. I miss the opportunity to do what we do so effectively in our bankruptcy system, which is solve problems. We are fundamentally a problem-solving enterprise in court. I think the commercial court in Paris maybe has some of those same attributes, the commercial list. In London, the same. We are brothers and sisters in this regard. It takes a village. We need the courts, the neutrals, the arbitrators, the mediators, the experts. Of course, P.R.I.M.E Finance has a role, I'm sure. The lawyers, the clients, to bring their best game, to rise to the occasion, to appreciate that this is probably not the time to cut a corner because the system is at risk of a bit of fragility if that kind of step takes place. I think the lawyer's reputation and the reputation of court systems have never been more important because we are trusting in those now to some extent. Of course, we don't just blindly trust. That's not part of the process. But I think the lawyers who understand and appreciate that, and business people, financial advisors who see that, are the ones who are really going to excel in the current environment, because it is a difficult environment. It's not permanent, but it is here for a while. And some of the lessons we're learning, I think, are going to stay with us. Finally, I have to acknowledge my real appreciation. I've participated in quite a number of these kind of programs and listened to many as well, to learn from the experiences of my colleagues within and outside the United States. And I was really struck by something Sir William said about how it's not easy. It's not easy for judges. And I have sometimes struggled a bit, this is quite personal, to recognize that, because it's never supposed to be, it's never more or less easy or hard. It's just the work we do. But it is different. The energy that you get from 6 or 7 hours, as I had yesterday, of more than 100 telephonic hearings, alone in your office, alone in your courthouse is very different than the energy and the interaction with the bar that you feel and sense and appreciate and sustain in a full and active courtroom where lawyers are doing the best work they do to solve problems for their clients. So that's a little bit of a view from the United States Bankruptcy Court. We're managing, but I miss the courtroom. I miss seeing you all, and I look forward to seeing you soon. Back to Rick.
Judge Stong, thank you very much for your remarks, and also for teeing up the first question that we have from the audience. You referred to it. I'd like to go to it right away. It comes from Pierre de Revel d'Esclapon, and his question is, what role, if any, do you see for mediation in handling the types of disputes discussed today? Will your answer vary according to type of disputes? In a number of cases, parties are interested in maintaining long-term commercial relations. Why don't we go, Sir William, since you touched upon mediation and the public policy imperatives that exist for avoiding costly disputes, if possible. Let me begin with you, and then we'll go in the order in which each of you spoke to address this first question.
Right. Well, it's a good question. Very briefly, the approach that we've taken with the kind of high-value financial and business disputes that we're really talking about today has been not to put pressure on parties to mediate, but to give them opportunities to mediate. So at an early stage in case management, that kind of thing, the question of mediation will be brought up. But I think that times may be beginning to change. In many jurisdictions, mediation is compulsory. Courts will order it, or even it's compulsory prior to bringing proceedings in countries like Switzerland. So I see, I think for the reasons that all four of us have touched on, this kind of public interest where society's providing a huge liquidity. I just think that arbitrators and judges are going to expect more reasonable conduct than necessarily they've expected in the past.
Thank you, Sir William. Jean, any thoughts on that subject?
Very briefly, we're all in favor of mediation as we are in favor of conciliation. The problem is that sometimes the lawyers, that's to say the barristers in France who defend their clients, prefer not to have recourse to mediation and prefer to go to court because it's more remunerative. But we are all in favor of it and would like to push it as much as we can.
Thank you. And Judge Stong.
You know, I have a rule of thumb that I try always to follow before this happened, and certainly does as much now. Before I'm scheduling an evidentiary hearing or a trial, even if I'm biting my lip to keep from smirking, I'll say, have you considered whether mediation might make sense here? It's part of my standard pretrial order. I require the parties to confer and advise the court whether they think it might be useful. And I've really realized over the years that there's one person in a courtroom who has an ability to ask that question in a different way than anyone else, and that's the judge. No one is going to think the judge is showing a sign of weakness to propose that the parties consider a settlement or a mediation. And so, if anything, that's all the more important now, I think. There's a lot of wisdom out there and a lot of developing expertise on how to conduct mediations remotely, how to use complex video platforms that permit caucus sessions and things like that to take place. So I think I'm cautiously optimistic that we will get even smarter about good ways to use this tool. Not every agreement can be reached through mediation, and not every case can end in an agreement, but I think we'll get better and better at looking for the opportunities to do it just because of the exigencies of the current circumstance.
To stay on this topic for just a moment, we've gotten another question that comes from Barry Fletcher, and one of the points that he asks in his question is, do you think we will see more jurisdictions legislating for mandatory ADR in certain circumstances? So any quick thoughts on that point? Let's go in reverse order. Judge Stong, any thoughts on that point?
Yeah, I'm happy to take that one to begin with, because of course, if you practice in New York, you know that our chief judge in the Court of Appeals in our state court system has adopted a very earnest policy of presumptive mediation in all civil cases, or most civil cases. And so we are living this in the New York state court system, and I think it makes sense. It takes what, 30 seconds, not even, to pose the question. If it's built into a system as a necessary step, as a former litigator, I would say not at the very outset of a case necessarily, but once the parties have some common ground in terms of knowledge about the issues and facts, I think more and more. I think you're going to see this, and just as good case management, not only as a response to the pandemic and the limitations that it's put on everybody. I don't recall who said never waste a crisis, something like that, but it's a good example, I guess, of never waste a crisis.
Jean, any further thoughts on that point?
In France, there are already a certain number of situations where the judge has to ask the parties whether they have tried to use alternative methods of settlement before the judge even looks at the case. And in the commercial court, in fact, this is, I would say, relatively widely used. There are a number of cases that go to conciliation or to mediation, less to mediation than to conciliation, because conciliation is free, as virtually all justice actions are free in France. At least there is no legal cost, if you will, the way there are in other countries. So in fact, the idea is that everybody's been pushing as strongly as possible, if only because the courts are overcrowded or overburdened with cases, as the law already requires people to have an attempt at alternative methods of settlement before they go to court.
Thank you, Jean. Sir William, any thoughts, any additional thoughts on this point?
Well, just very briefly, the UK government has published guidance on settling cases, but I don't see any prospect of legislation being introduced, which I think was the thrust of the question.
Well, thank you. I'll just mention a matter in which I have been involved in the last couple of months that involved a mediation. Teamed up with, I'm a financial markets expert at P.R.I.M.E, teamed up with a disputes expert at P.R.I.M.E, where we did undertake a successful mediation of claims between a financial institution and a number of banks. And the motivation there it came from the various parties. They saw that it was in their mutual self-interest to resolve the issue and avoid a costly either bankruptcy proceeding or other litigation. The time and the money that would have been involved was motivation enough to bring them to the mediation. So that's not to say that there might not be a role for compulsion, as there was in the Lehman bankruptcy case in the United States, where Judge Peck made it clear that mediation was a route that needed to be tried in a number of the cases before he would actually hear the cases. But certainly there's self-interest in ADR, resort to ADR procedures. I'd like to move on to another series of questions now that relate to technology. And we've got several people who've asked these questions, related questions. Jeffrey Aristide, William Janis have among them. And the questions relate to the role that online dispute resolution technologies, blockchain technology, the remote hearing of cases will play in the future. We all hope that COVID-19 is addressed hopefully sooner rather than later by therapeutic drugs and hopefully by a vaccine, and that we will get past this pandemic. But will some of the lessons that we've learned from this crisis, some of the techniques that we've employed to keep our dispute resolution processes going, will some of them survive this event? And let me turn first to Sir William, and we'll go again in the order in which we've spoken.
Absolutely, they will survive. I think it will be one of the major changes to commercial dispute resolution that we've seen for a very long time. Just on the point you raised about blockchain, yes, there may be a place for that. It's being used in a new dispute resolution scheme for small claims, introduced a couple of weeks ago by the London Chamber of Commerce. The advantage of possible advantage of blockchain in this kind of situation is that you can have verified documents that that can't be altered, and that can be quite important in a lot of contexts. But I think we've got to start now taking remote hearings really quite seriously, and not just, I think Judge Stong made this point, not just dwelling on the advantages, we could all understand that, but trying to identify as well the problems and how best to deal with them.
Thank you very much. Jean, thoughts on?
Are we trying to answer the question about the blockchain technology?
Not necessarily specifically, but whether the processes that we've put in place, the remote hearings and other methodologies have been put in place to keep our dispute resolution mechanisms going, whether some of these will survive a return to in-person, the ability to be in person again. Will some of these, remote testifying, for example, will some of these survive?
Personally, I tend to think that they will not really. There are plenty of cases that can be dealt with on a remote basis, but commercial litigation of some significance, really, I strongly believe that the in-person hearings are much more, in fact, useful for the judge to understand what the situation is and what the parties are like. And I don't think that there are plenty of cases where you have the possibility of continuing to have remote hearings. But on the whole, I think that these will be, for instance, for the payment orders, what we call injonction payée, which are, very sort of automatic in a way. You provide the evidence and you get the answer. But as far as disputes of a commercial nature are concerned, I think that we will much prefer to go back to the hearings in person.
Well, thank you, Jean. Judge Stong, before we wrap up, a quick final thought on this topic.
Yes, indeed, and happy to get the last word. Here's the point. I think what we're learning, I hope what we're learning, and it's a great set of questions to end on, is that maybe it's not either or. Maybe it's not, are we remote, are we in person? Maybe it's not, are we all in the courtroom or are we never in the courtroom? When can we go back to normal? Does anyone even use the word normal without saying new normal at this point? I don't think so. I don't think it's either or. I think the lesson is it's both and we have filled out our toolkit with some new tools. We didn't want to, frankly, we were pushed to it. We had no choice, but we did it. We did it a little over 100 days ago. And I think we've learned, and this is implicit in the questions, that there are things we can do online. There are things we can do remotely. For me, it's important not to take the people out of the equation, not to take the lawyers, the lawyer-client relationship, the lawyer-lawyer relationship, the judge, to keep all of that in the problem-solving process, but to recognize that really at its best, this is both and, not either or, and we'll take the best from what we're learning and get back to the best of what we're missing and hopefully have a better, stronger process as a result. Thank you for the last word.
Thank you very much, Judge Stong. And before I mention in a minute a couple of upcoming events in this Primetime Live series, I'd first like to say I agree that was an excellent place to end, but I'm very sorry that we have to end now because we have a number of unanswered questions. And for those of you whose questions we've not answered, they will be reflected back to my fellow panelists. Feel free to get in touch with us. Those of you whose questions have not been answered, and those of you who have questions that you did not yet pose. I'd like to thank my fellow panelists for their excellent contributions. I'd like to thank the many attendees for their attendance, especially again those of you in Asia who stayed up very late in your evening to join us in this event. As I said, this event is one of a series of primetime virtual events. On July 7th, we will be having another event at the same time. Apologies again to those of you for whom it's not particularly convenient, but it'll be at this same time on July 7th. We'll be talking about financial regulation in a pandemic, and our guests will be Tim Massad, former chair of the U.S. CFTC, and Kay Swinburne, who was a European parliamentary EMP, former vice chair of the European Parliament's Economic and Monetary Affairs Committee. That's July 7th. On July 14th, we're going to have a couple of senior experienced market experts discussing the events of recent months. They will include Gay Evans, who's a former banker at Bankers Trust, and Barclays, also former regulator at the UK, what was then FSA, and now chair of the London Metals Exchange, along with Blythe Masters, who was very instrumental in developing the credit derivatives market in her many years at JP Morgan. And that panel will be chaired by Tom Jasper, who was the first chairman of ISDA. So those are July 7th and July 14th. I'd like to thank very much Dwa Financial Technologies for their sponsorship and MLEX for their support. If you're interested in sponsoring any one of these events, we'd certainly welcome that. Please do get in touch with Camilla McPherson at the Prime Finance Secretariat. In addition, I should mention that Prime Finance is a not-for-profit organization, and in addition to sessions of this sort, we do a considerable amount of judicial capacity building around the world in the interests of facilitating, furthering more capable adjudication of financial markets disputes. And we do accept donations to support our work. If you'd like to make a donation or find out more, please contact the Secretariat using the details in the chat box. Again, I'd like to wrap up by thanking my fellow panelists very much and to thanking all of you for attending this session. Hope to see you on July 7th and July 14th. Thank you and goodbye.